Hey guys, Sent here with Sent's Law Firm. Before we start, I'm asking that you guys please like, share, comment on my videos, and also go to my YouTube channel and subscribe because it helps me a lot. It keeps me motivated to continue making those videos for you guys. Today we will be speaking about specific issue that affects your right as a consumer that you probably didn't know existed, or how impactful it is with respect to your rights as a consumer. Have you ever entered into a contract or bought a used car, and when you looked at the contract and saw the words "as is" written on there? What does that mean? Sometimes it shows up as "with all faults" or "no warranties," something to that effect. When you see that, it is important. I need you to pay attention to it, because what that does, it waives certain warranties, certain promises that the dealer would have made to you impliedly without even expressly saying it to you. The law recognizes them. Two of them, implied warranty of merchantability. What that says is that if the dealer sells your product or the seller sells your product, the product does what it is it's supposed to do. For example, if you bought a vehicle, if you bought a car, there's an implied warranty that the car will drive, right? That's just implied in the deal. The dealer doesn't have to expressly say that to you. There is also another one that is important, implied warranty of fitness for a particular purpose. This is a long way to say that if you rely on a seller's skills to buy a product for a specific purpose, and the seller presents to you that that product they presented to you does what it is you're looking for, that is the implied warranty of fitness for a particular purpose. To use the car example, if you went to a dealer and say, I need a truck that can tow a specific type of boat to go to the lake, and then the seller went and said, hey, this specific truck can do it. Once you bought that truck, you're relying on the seller that the truck will do what it is exactly that you need it to do. That is implied warranty of fitness for a particular purpose. And once you see as is, those two implied warranties I just described to you here, they no longer exist in your contract. They're not making that promise to you anymore. That is how important it is to understand words as is when it comes to your rights as a consumer. How does that interact with consumer protection? Here it is. Once you don't have those warranties, that means if something were to happen, you find out later something happened to your vehicle, you essentially are out of luck, especially if they have a well-drafted as-is clause in the contract. But as a consumer, a lot of times you'll find yourself against sellers or dealers who would be abusing that as-is clause. A lot of sellers, they're hiding behind that as-is clause as if that clause is a blanket liability protection, like a full-blown protection, meaning that they're liability proof. That is not the case when it comes to your right as a consumer. Yes, as-is is important. It is powerful. In fact, it may be one of the most powerful tools a seller will have against you as a consumer, to disclaim everything, to say, you know what? Yes, something is wrong with your vehicle, but I sold it to you as is. That means a lot of them think when they say as is, it means that they didn't make any promises to you. A lot of the times, that's how sellers and dealers, especially used car dealerships, that's how they use it. That's not the appropriate way to use it. When they use it that way and you allow them, essentially you're giving up rights that existed somewhere else that you probably didn't know. If they're lying to you, they lied to you to buy the car. If they had certain important defects with the car, things that if you knew, you wouldn't have bought that car, you wouldn't have purchased that car. They can't just use as is as a blanket liability protection while they lie to you elsewhere. A lot of times they will make a lot of false promises to you outside of the contract. It's not written anywhere, but the salesman or the seller will say, hey, you know what? If you buy this car, 30 days down the road, something is wrong with it, I will fix it free of charge. That is something that is contrary to the as-is clause. When that happens, the law in Florida says as-is generally waives those implied warranties, except when the circumstances show otherwise. So that means when the circumstances show otherwise, usually that could be the seller or the car salesman saying something to you completely outside of the contract. It's not written anywhere in the contract, but they're making all these promises to you that you could use to say, yes, you sold me this as is, but at the same time, you told me this. So this is conflicting information. And as a consumer, you have the right to fight those. You don't have to take it laying down when the seller is telling you, I sold it to you as is, therefore I made no promises, thus I have no responsibility to do anything to fix what's wrong with the car you bought or with the product that you bought. I need you to pay attention when you see the as is clauses. Treat them with respect because they affect your rights significantly, especially when they are well drafted. But know that it is not a liability protection for dealers, for sellers to lie to you, to promise one thing and do something else. I need you to understand that. Of course, we're always asking you guys to pay attention to what it is that you're signing. Okay, if you're buying a product, if you're buying a car, pay attention, read it. See the as is clause, ask questions. And if they're making promises to you outside of the contract, have it written down somewhere. Take your own notes. Just make sure that it is recorded somewhere that you can use it later down the road, because it's more difficult to establish in court what they said to you if it's not written anywhere else. Get it in writing. If you talk to them over the phone, go ahead and send them a follow-up email saying, hey, based on our conversation, this is what we talked about. At least you have it in writing somewhere. Do that immediately after that phone conversation. And in that way, you protect yourself in that sense. This is what I wanted to talk to you about. There were a lot more to it, but of course, this video had to be brief. But of course, feel free to comment. Okay, but do not ask specific questions in the comment section. If it's a question specific to your case, do not ask about it, because that breaks confidentiality and they can always use that against you. All right. And again, guys, this video here does not create an attorney-client relationship between you and Sense Law Firm. It's simply for educational purposes, simply to inform you of what's going on, to make sure you understand your rights as a consumer, especially in the states of Florida. I'm not sure how that interacts with other states. Your state may have that, but make sure you take a look at it. Make sure you speak with a qualified attorney to see how they can help you out. But know that when you're buying used product, specifically used vehicles, there is that as-is clause that is always at play in that contract. Yes, as-is is contract. It could be warranty law, but it interacts with your rights as a consumer. Keep in mind what you need to establish when you're in court in Florida to win under the FDUPA case. You need to show that they acted unfairly or deceptively, and as a result of that, you suffered actual damages. Go ahead and speak with an attorney, call and see if they can help you out. But for now, we're going to go ahead and stop the video right here, and then we will talk to you guys about some other issues in the other videos. All right, have a great one, guys. Bye.